Counsel, good morning.
Good morning.
Let me inform you that the 4 justices hearing this case will decide this case. We are the quorum. So with that, I will turn to Mr. Baylor for your argument.
Good morning. May it please the court. Jeffrey Baylor for Jessie Williams. I'd like to first address the issues involving the jurors, unless the court wishes otherwise. First off, we contend that so-called juror 11 was improperly dismissed, or a mistrial should have occurred where the reasons for his dismissal were not personal to him. In order for a dismissal to be appropriate, the reasons for the dismissal must be personal to the juror and cannot be related to his or her relationship with the other jurors. Here, from the juror's note and inquiry and even the judge's findings, we see that the reasons for the dismissal were, at least in part, related to his relationship with the other jurors.
Can you answer this question, Mr. Baylor? What was Judge Pierce to do? So he says to, and we'll get into the other juror in a second, he says to this juror, or he says to the juror, you have to deliberate anew.
Right.
And then we kind of have a mixed bag. We have this juror saying, I can't and I won't deliberate anew, i.e. I won't follow your instruction. But then he also says, and the reason I'm not going to do that is because everyone hates me, essentially. Everybody disagrees with me. So what should Judge Pierce have done short of a mistrial?
Well, I mean,
I'm sorry to interrupt you. Could he have said, go back in there and do your best?
Yes, and he could have done that because, especially because the juror didn't say, I can't follow your directions. He said he wasn't 100% sure that he couldn't follow the directions. But even if he says he couldn't follow the directions, then a mistrial should have occurred. I mean, the cases I cite in my brief say that, it's costly for everyone involved, but sometimes you get a juror that just requires a mistrial. And here we see that the juror's issue was based on his relationship with the other jurors. So therefore it can't be found totally personal to him. I'm sorry.
Yeah, and thank you. Because we have an extensive colloquy and very particular findings by the trial judge. We owe deference to his assessment of that juror, correct?
Correct, but as a matter of law, the juror could not be dismissed under the rule when his issue is related to the other jurors.
Okay. Go ahead, just Sam. I'm sorry.
No, I'm all set, Just Cipher.
Attorney Baylor, going back particularly to the colloquy that the judge is having with the juror, where do you identify that it's particularly related to the other jurors?
Yes. Well, first of all, the court received the note from the juror saying, among other things, that he was not able to engage in the discussion with the other jurors. He could not have a discussion without being judged. Then an inquiry was held.
No, let me stop you there for a minute. Was that note about he says at this point, I know the other members are waiting on me, so I don't think I would be able to have an open discussion without feeling judged. Is that more about the fact that he is interrupting the proceedings, or is it because I took that a different way, I think?
Well, during the inquiry, the juror said that is part of it, but that was just a minor part. In the note, it also said that he couldn't engage in the discussion with other jurors, but the judge that he was being judged. So maybe he didn't feel like he could, that they were waiting on him, and that was a problem. But he also felt like he couldn't return because they were judging him. But I think in the inquiry that occurred afterwards, it's even clearer that his issue is related to the jurors, and that he may well have been the only dissent. In the inquiry, he said, I already know specific jurors that I disagree with. I know how it goes in there. And even the court in its findings stated the juror has views different from others. So the juror might have said, I'm not 100% sure if I can follow the directions, and might have, in a minor part, felt like he couldn't return after delaying the jury. But it really comes down to the reasons that he wrote the note in the first place, and that is that he already knew specific jurors that he disagreed with, and he felt like he couldn't start all over again.
Where is that specific point? Could you, where do you discuss that in the brief, that there are jurors he disagrees with? Or where in the record is that?
I have it when there's an inquiry. It's on page 32 of my brief. Let's see. It's transcript 2515, where the juror says, I could read you the quote. I've already made up my decision. I already know specific jurors in there that I disagree with. So going in there with a new person who has to start over, I feel like I already know what I'm going to say, and it's going to be biased and not fair for me to be in there.
I'm sorry, isn't that the point of deliberations anew? So maybe it's a fiction, but we're supposed to say, all right, you're now a different group of 12. You start at square one.
Right.
And he's basically saying, I can't do that and I won't do that.
Right, but his reasoning is because he already knows that he disagrees, that certain jurors disagree with him. And then in fact, once he's removed from the juror and the alternate, that's it, it was put on the jury, they came back with their decision very rapidly. So
Right, Mr. Beal, can I get you to the alternate juror in a second, and maybe if we have time, you can go back to that juror if need be. What strikes me about this case is, number one, isn't it wrong for the lawyers to say, let's rig the alternate system?
In a case that occurred after this case, I think the court made that clear, that that's not an acceptable way to do things.
Right, and then there's a statute about prejudice, but that's not, and the defense attorney below said sure, right?
About this alternate procedure. I think the defense attorney, in fact, said that, in the past, that's the procedure they've used, and there's no embarrassment or trouble caused to the other jurors. And at the time, the trial judge said, well, do you want a voir dire? And they said, and the defense attorney said, no, let's just make sure that he's going to be an alternate.
Okay, and that leads to my second question, Mr. Bailey. So what can really, I find troubling about this case is we have a statement at volume 11, pages 5 to 6 from an experienced judge who says, I had a colloquy with this juror and he wasn't sleeping, he was concentrating. That's not apparently in the record. What steps were taken when this record was assembled to ask Judge Pierce, was this something that happened? Did the court reporter not pick it up? Was this done in the lobby? Because I'd hate to make a ruling on this case, and if I were the trial judge and I had a colloquy, and then the SJC is saying the judge should have had a colloquy, I wouldn't be too pleased with this court. So what steps were taken by you folks down below to shake this out?
Well, I mean, I know that's not in the record, but I talked to the trial attorney and the defendant, and it appeared that there was no colloquy. I don't believe that it's clear that when the judge is saying he said, yeah, I spoke to him or I inquired. To me, it appears that he spoke to the assistant district attorney, not that he spoke to the juror.
Oh, the him is the ADA?
That's how I read it. I don't have it right in front of me, but if you read the whole,
I just read it. I read it again this morning. I spoke to him.
okay.
His hands were in his head. He was concentrating.
But if you read what the defense attorney said right before, when the defense attorney says, object, I don't want, he should be an alternate. The defense attorney said that there was a problem with this juror in that he shouldn't be he should be an alternate, meaning that there was never an inquiry and that there was a problem with him. And so that leads into the judge saying, well, I inquired of him.
And help me out, Mr. Baylor, as far as, I think we've said it's structural error, but if a defense attorney essentially waives a colloquy,
Yes.
so it's not, there's no need. And then I guess the issue is whether or not the report of the person sleeping is reliable. That's the first step. But anyway,
Right.
if the defense attorney says, nope, we don't need a colloquy, can that issue be waived?
Well, it cannot be waived because it's a structural error. And I cite a case from this court in my brief, which I don't recall the name of off the top of my head.
That obviously makes sense of structural error. So if there was reliable evidence that this person was asleep, no matter what happened with the request for colloquy, it's a reversal.
Right. If there was no inquiry of the juror and a finding that he or she wasn't asleep.
Counsel, is this a situation where Rule 8 would have worked to make a motion for the judge to reconstruct the record of the inquiry he made?
Well, I didn't believe that based on the record that there was a missing portion, and the Commonwealth could have just as easily moved to correct the record if it had believed that there was something missing.
Either one of you could have, but I'm
Right,
wondering if
that's
this is where it doesn't appear either party was involved. That's, at least if the lawyers are in the room and something happened during trial and it's not in the transcript and there's a motion to reconstruct, we're a little more aware of what we're reconstructing. But here, I'm just wondering if that would be a mechanism that would have worked. Not necessarily critiquing you for not doing it.
I mean, it could have worked, but it didn't appear from the record or from what the judge said that there was
It just seems unfair to me that we would make a finding of structural error with this looming question about whether or not there was an inquiry.
Well, all I can say is as it appears that there wasn't one. And that's as far as, that's what's in the record, that there wasn't one, and that it appears from as I said, from what the trial lawyer said, the defense lawyer, that there wasn't one. And if you read what the judge said closely, I believe he's referring to the assistant district attorney, not to the juror.
Is that because he thought that they were basically going to make this guy an alternate, so it would be no problem with this guy?
I'm sorry.
I thought, I was under the impression that they didn't do a colloquy, if they didn't do a colloquy, because the notion was that he was going to be an alternate juror and he wasn't going to be a problem anyway.
Right. Yes, that's exactly right.
But that was raised before because we had there was another, he puts him in the mix to be an alternate a prior time over the defense attorney's objection because, and then this is a second juror who's excused for cause, right? So there were plenty of opportunities to have a colloquy, and the issue was raised to the judge about whether or not this person is a proper juror, correct?
Right, yes. Right, well.
You frozen?
Before then, I'm sorry.
Mr. Baylor, just you froze a little bit, so I don't want to miss what you said in response to my question. Why don't you start all over again?
Okay. I'm sorry, what, do you recall what the question was?
You know, I was just asking you about, this was the second time this issue was broached.
Oh, yes, yes. It appears from the transcript that there was no making that juror an alternate when the first jury was selected. It just by happenstance he wasn't, or I can't remember if it was a he or she. That juror couldn't, I think it was a he, couldn't. Nothing said that the juror couldn't be selected. And
So
at
they
that
didn't,
time,
they didn't say on the record, we palmed his
No, they did
his
not.
number.
no. And then in the second time he was picked. So it appears that it was just happenstance that he was not picked in the first part of the jury. The first part, yeah.
You have some time remaining, Mr. Bailey. Do you want to address your motion to suppress argument?
Yes, I would. And just getting down to the central issue, and of course we say under the totality of the circumstances, the statement was involuntary, and primarily because Mr. Williams invoked counsel. During the middle of the interrogation, before Mr. Williams had admitted anything, he said, I have the piece of paper right here. I was going to say whatever, but this is where the lawyer thing comes in. So I know that this is an unsophisticated way to say it, but he's basically saying, I was going to say whatever, meaning I don't want to talk, and this is where the lawyer thing comes in, meaning that he doesn't want to talk until.
What's the next response to the police?
Pardon me?
How did the police follow up on that?
Well, I mean, we contend that they should have just stopped questioning because that was an invocation of counsel. But then they followed up. You know, it is possible if it's unclear for the police to follow up. And even with the clarifying questions, Mr. Williams never said he didn't want a lawyer. I just can read it too. The police responded, okay, well, if you say the lawyer thing, does that mean you want to have a lawyer? Do you want to stop, or do you want to keep talking? And the defendant responded, no, I definitely like to talk. But he didn't say he didn't want a lawyer. All he said was he wants to talk, but apparently with a lawyer because he's asking for a lawyer. I mean, it was so unclear that the police asked him again, does this mean you want a lawyer? If you're saying you want a lawyer, I want to stop. But if you want to talk, I'm glad to listen. Do you understand what I'm saying? Mr. Williams responds, meaning he understands what he's saying, but again, never saying that he didn't want a lawyer. Then the police, still unsure, left the room to talk to the assistant district attorney who was monitoring the interrogation. And then police just came in and started questioning him again. There was never, as required, explicitly Mr. Williams saying that he did not want a lawyer. And once even if it's equivocal, the follow-up questions were warranted, and it's required that Mr. Williams say that he wished that he did not want a lawyer and want to continue. We have this unsophisticated defendant who's saying, you know, this is where the lawyer thing comes in. I was going to say whatever, meaning he wants to stop, and then the police just keep going.
Well, but don't they ask him, do you really want a lawyer? I mean, they probe him a little bit on this, don't they? Doesn't that,
Well,
isn't that what we tell them to do?
They ask, well, they're supposed to just say plainly, does this mean you want a lawyer? And they can't keep questioning unless they say, the defendant says, no, I do not. And they never do that. They just sort of ask them two-part questions. Does this mean you want a lawyer? Do you want to stop talking? And then there's never a clear statement from Mr. Williams that he will talk without a lawyer. It just says, no, I want to keep talking, but he's already asked for a lawyer. So I think, you know, he understands what's going on, but then police go out and to talk about this, and apparently they agree that it's okay for them to continue, even though the defendant mentioned the lawyer. but they just come in and they don't ask him anything again. They just go forward with the interrogation. So we contend that, first of all, it was unequivocal. And even if it was equivocal and the follow-up questions were required or warranted, that Mr. Williams never said that he wanted to go forward without a lawyer. I mean, he's, you know, an unsophisticated defendant. He's trying to apparently appease the police by saying, no, I'll talk, but he's asked for a lawyer. And he, you know, of course he doesn't know, you know, what the procedures are. And I think that he deserves at least the benefit of the doubt in this case when he's out, you know, when he basically says that he wants a lawyer.
Any further questions for Mr. Baylor? No. Thank you, Counsel.
Thank you.
Mr. Charles?
Unmute. There we go. Good morning, Your Honors. May it please the Court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. Just briefly, since you left off with the Miranda issue, I'll just briefly touch on the invocation of counsel. Our position, and I think the motion judge adopted this position in her memorandum of decision, is that there wasn't even a need to confirm an invocation here because what the defendant said did not rise to the level post-waiver of an unequivocal invocation of counsel. And I don't think it's fair for my brother to use the fact that the state police trooper here, in an abundance of caution, really tried to be sure that that isn't what happened, to suggest that that should count against the Commonwealth. I think clearly here, Trooper Baker twice attempted to get to the heart of any ambiguity that there might have been there. And you'll note from my brief, I think, and also from the transcript, that there's some dispute between the Commonwealth and the defendant regarding his unofficial version of the transcript, which we maintain does not accurately reflect what was said in that moment, and the video recording of the hearing, which I would urge the court to listen to, which I think reflects that the defendant said, no, I'll talk. And then even after that statement is made by the defendant, Trooper Baker still asks one more time. He says, if you're saying you want a lawyer, I want to stop. But if you want to talk, I'm glad to listen. And the record is that the defendant nodded his head positively and acknowledged. And I would also just, the last thing I'll say before I move on, unless there are questions on this, is if you look at the transcript of the motion to suppress at page 46, Trooper Baker's testimony was he did not have any doubt in his mind that the defendant had not invoked counsel when he left the room for that 3-minute period, that he merely left the room to make sure that anyone else watching didn't have a different opinion. But his testimony was that he himself had no doubt after that brief interaction with the defendant that he had not in fact invoked counsel. And you can see that after the brief recess, when they resumed, the defendant participates without hesitation. The matter is never brought up again. And so I don't think under the case law, there was a clear invocation here that even necessitated that additional back and forth between Trooper Baker and the defendant. I suppose next I'll move to the issue of the juror who was allegedly sleeping.
Why didn't you ask for clarification from Judge Pierce?
So I've sort of struggled with that decision in the past couple of days. It's obviously not in the record. I will note I did directly email Justice Pierce to sort of inquire whether he had a recollection in the first instance, because I thought that would have been prudent initially, to see if he even had a recollection before staying proceedings and pursuing a hearing. I unfortunately did not get a response. I'm by no means putting the onus on Justice Pierce. I think ultimately where the Commonwealth came out on this is our opinion based on the transcript was that this was not a reliable report, and that therefore, because no voir dire was required, it was not.
But what if we disagree with you? Then you got a huge problem of structural error.
Again,
which could have been remedied by asking a trial judge to look at his notes.
Again, I think that I've struggled with it over the past few days, recognizing candidly that I think it sort of fell to the back burner when I started writing the brief. And I think in an ideal world, we probably would have stayed this and gone back down. I guess I would ask the court, if you disagree with my legal argument, as you have in some other cases, or I believe at least as I've seen the appeals court do in circumstances here, that it be sent back down for further clarification on this one issue. But again, I think the Commonwealth's position, and I think it's a pretty strong one, is that this was not a reliable report. While unquestionably the trial ADA did initially say he's been sleeping through the whole thing, If you look several lines later, he sort of immediately qualifies that and said, well, he had his face down in his hands. Maybe he was just listening. And the judge sort of acknowledges that you don't have to watch the interrogation. You can just listen to it. And I would say here, the other key distinction.
But then he adds, and I spoke to the trooper, and the trooper said he was nodding off during the surveillance video.
So with all due respect on that point, the trooper, he does not say that the trooper said he was nodding off. He just simply says that the trooper said he wasn't paying attention.
The nodding off is my gloss, but he says there was a problem. The trooper reported a similar problem.
And I would note that the trooper was when we're talking about the trooper, we're talking about the individual who had just finished testifying, who introduced the tape that was played. But I would also, what I was about to say is that the key distinction here, I think, is you have a judge who basically says repeatedly, I've been watching him during this relevant period of time, and I did not see that, and that does not gel with what I have observed. So if you look immediately when it's brought up at page 20 of volume 8, Judge Pierce's initial response is, I did not notice it. And then at the very next page, page 21, I was watching the jurors throughout, I did not see that. And then he elaborates even more farther down page, because I have been watching. So that, I think, squarely puts this case in the camp of Benesh and sort of these other cases where you have one party who alleges that there was possibly a juror sleeping. And here, again, I would say that the trial ADA almost immediately qualifies it or minimizes it. And you don't have any other person who observed that conduct, who directly spoke to observing that conduct. And you have a judge who is saying that he did not see that. And he had been, not that he didn't see it because he wasn't watching, but that he was watching and he didn't see it.
Two questions. Why does the judge then say, I made an inquiry?
So obviously, that's obviously several volumes later.
I know that's on volume 11 at the end of the trial. Do you have the same take as Mr. Baylor, that the inquiry was the inquiry to the ADA? Or do you think that the judge did have an inquiry that somehow didn't get transcribed?
So candidly, I initially had the opposite reaction, similar that there had been a voir dire and it simply was not recorded, as evidenced by a footnote that I put in my brief. But upon rereading the defendant's brief, I don't think it's unreasonable, his interpretation of it, because in looking back, the explanation that Judge Pierce gives at that point is exactly the explanation that the trial ADA gave when he qualifies the initial observation, that he had his hand in his hands to focus and pay attention. So I'm not sure that is, I mean, there's the pronoun use there is not ideal. I think he could simultaneously use the same pronoun to refer to the trial ADA and the defendant. So it is conflated a little bit, but I do think that that's a plausible explanation. I'm just not certain which is but I do just want to say, again, the fact that Judge Pierce, in an abundance of caution, decided to offer the prospective voir dire does not change the fact that this was not, under the case law, a reliable report. I think if you look at Benesh, and before I get to Benesh, I just want to say, our case law is replete with instances of a party to the case, a defense attorney or a prosecutor, making an observation that is then deemed unreliable. So just the fact that it's a party to the case making this observation doesn't inherently imbue it with reliability. If you look at Vaughn, if you look at Benesh, and then Keaton, which I didn't cite in my brief, is 36 Mass App Court 81. All of those cases, I believe, was a defense attorney made an observation of a sleeping juror, and then the court found that it was unreliable.
It's a bit odd when it's your party to the case.
I understand that, but I don't think that a prosecutor because it was a prosecutor, should necessarily be imbued with greater reliability than a defense attorney. I think we expect all the parties to the case to make observations. And I think
let me ask you about rigging the alternate system. Was that improper?
I think under the statute, if the parties agree, though I recognize, as my brother said, that there was a case that came out afterwards, I don't think the process was rigged. If you I
thought the statute says that they have to be chosen at random.
I believe the statute says if the parties are in agreement, there can be an alternate, I'm struggling with the word, an alternate procedure, as long as all of the parties agree. But again, here, if you look at volume 11, page 5, the judge basically instructs the clerk to select another alternate from the original alternates who were selected at random. And I think based on that observation there and the absence of any record in the transcript that there was an agreement and that there were any steps taken to intentionally make this juror an alternate, I don't think you can infer that that was done. And I don't think the transcript supports that that was done. The defense attorney here suggests that that's something he's done in the past. The prosecutor sort of agrees that that's something he's done. The court in the moment never agrees to it. There's no subsequent indication that the court took that step. So I think this juror just became an alternate through the luck of the draw. And then when the defendant brings it up again at volume 11, the judge reiterates that he had been watching the juror. He says, I'm watching, regardless of what he said, how we interpret the did he or didn't he voir dire him. He says, I was watching the juror personally, periodically throughout the trial. I have concluded that he was fully attentive from beginning to end. So I think you have a judge who is vehement in his assertion that he was watching this juror, that he did not observe the conduct that the prosecutor asserted took place. You have a prosecutor who qualifies his initial observation by saying, well, maybe he just had his head down in his hands to listen. And so I think if you, by the letter of the law, based on the cases this court has decided, that doesn't qualify as a reliable report of a sleeping juror.
Now, with respect to the other juror, he kind of gives a mixed bag because he says, I'm not going to deliberate anymore. But he also says the reason I'm not going to do so is because of the position I have in this case. Isn't that second explanation personal to him? It has something. It's not straight. It's the opposite. It has something to do with his feelings for the case, not personal to him.
Correct. So to me, this is almost. I'm not saying that this is verbatim the Swafford situation or the Leftwich situation, but this court has sort of recognized in those cases that even where there is this tangential relation to the larger deliberations, there can still be these idiosyncratic responses from jurors that necessitate that they be removed. And I would submit that here, with the three alternatives that were open to Justice Pierce, which was to let this juror remain, remove the juror, or declare a mistrial, that the course of action he took was unquestionably the most reasonable course of action to take. I mean, this is certainly not a situation this court has been presented with before. We have a jury that was now in its third iteration. They were just about to start deliberating. So there's no evidence in this record that they were at an impasse, that they were deadlocked. I would dispute my brother's characterization, and I would say that the trial judge's findings, which you have to credit unless they're clearly erroneous, suggest that he was not a minority juror.
He may not be a minority juror. He may be in the majority or the minority. But there is disagreement because he's expressly saying they're jurors I disagree with, right? He makes that point expressly, right?
I don't disagree with that, but I think that in almost every case, there are always going to be jurors that disagree about certain things. I don't think the fact that he happens to disagree on certain ethereal things, undefined points with other jurors.
Why do you say they're ethereal? I already know specific jurors in there that I disagree with.
So that's perhaps not the right language. I apologize for cutting. I just mean that we don't know what he disagrees on. We don't know if he's in the majority and the minority, if he disagrees on a specific point of law, or if he just disagrees about but again, I'm not sure that necessarily matters.
Even if he's in the majority, I mean, kicking off somebody, because, even if you're kicking off someone in the majority, that's still no good, right?
If there's not a justified reason to take them off the jury, I would agree with you. But here you have a judge who conducted an extensive colloquy with this juror and just repeatedly tried to assure him that he wasn't trying to have him abandon his positions. He wasn't trying to change his mind, but that he had to follow the judge's instructions and go back in. And this is obviously not Oliver Ria, like I cite. That was a case where a juror brought extraneous legal information in and could not abide by the judge's instruction to disregard that erroneous legal instruction. But it's a good analogy because you have a juror who will not follow the judge's instruction. It's admittedly not an instruction that is typically at issue in these instances, because again, this is a unique case where the jury was reconstituted 3 separate times. But be that as it may, one of the instructions that he has sworn an oath to follow is that he will start deliberations anew when there is a new juror placed in, and he will engage in deliberations. And this juror refused to do that repeatedly. He didn't even, frankly, he waffled even on whether he could be a fair and impartial juror, if you read the transcript. But I think what is a judge to do when he is faced with someone who has removed himself from the jury, who refuses to, not I would say because of his disagreements, but just because he's like, I've figured this case out. I'm not interested in talking about it anymore. I don't think that that is necessarily a result of the views other jurors have or the disagreements he has with other jurors. That's a personal thing. He has decided the case. He's not interested in talking about it anymore. And he's refusing to do what the judge is instructing him to do, which he is legally obligated to do, which is to engage in a new round of deliberations. And I just, I do have to comment, my brother makes it seem as though that he was a minority and there was this holdout and then the jury convicted immediately after he was replaced. If you look at this, there's no trial errors alleged in this case. The evidence is frankly quite strong against the defendant, including a confession and numerous parties who identify him as someone who shot the victim who survived. And if you look at the prior iterations of the jury, none of them deliberated for even a full day. And neither of the prior iterations of the jury had their question to the judge answered yet, which was a technical legal question that concerned corroboration of the defendant's statement and whether they could use reasonable inferences to get that circumstantial corroboration of the defendant's statement. So I would just submit to you that the jury really wasn't very far along in the deliberations and they weren't going to come to a verdict until they got an answer to that question. And because they submitted that question pretty quickly the third time around when they were reconstituted, because essentially they'd already asked for an answer twice and hadn't gotten it. Once they got their answer to that question, then it's not surprising to the Commonwealth that it only took them another 3.5 hours to convict this defendant, because this was not a case where the evidence was frankly in doubt. It was a very lopsided case. The defendant didn't really put on any defense other than to call Dr. Newman Polk to try and poke holes in the voluntariness of his statement based on his childhood and school records. And so, while they did acquit him of assault with intent to murder, they found that he didn't intend to murder anybody when he fired the gun. The evidence was quite overwhelming and from a joint venture perspective that he was all in on this armed robbery. And that his co-venture clearly shot and killed Mr. Puopolo. So it's not remotely surprising to the Commonwealth that when this juror was replaced and there was finally an answer given to the jury's question, that this was a fairly short deliberation. But I think, again, it's just a judge has to be able to make what is a reasonable decision in the moment. And I think here, certainly you can't keep someone on the jury who is refusing to follow the judge's instructions. And to declare a mistrial where the jury as it exists in the moment has not deliberated at all, where there's no indication that the prior iterations of the jury were deadlocked or at an impasse, and where the judge has made a finding, unlike some of these other cases where you've reversed, that this is not a minority juror, which, although I take your earlier point, Justice Kafker, that majority minority, we certainly don't want to be removing people. This court has been pretty clear that you have to be extra cautious in trying not to remove a holdout juror. And I think there's no indication from the record here, or at least the judge's findings support the conclusion that this was not a holdout juror. And this was a deliberation that was just about to get underway again. And I would submit that in that circumstance there, it was reasonable to remove this juror who would not abide the judge's instructions. And it did not make sense there was not a manifest necessity for a mistrial there, where yes, he disagreed with people, but the disagreement was not the fundamental basis for why he had to be removed. He had to be removed because he was done. He'd made up his mind. He wasn't interested, even with talking with the new juror who hadn't contributed to deliberations at all. He just wasn't interested in participating anymore. He refused to say that he could. And the judge just didn't really have a choice. They had viable alternates, 2 remaining. And so the judge took the most reasonable course of action. And I would submit it wasn't an abuse of discretion and it didn't run afoul of this court's case law in that regard. If there are no further questions on any of the other issues, I would rest on my brief and ask that you affirm the defendant's convictions.
Thank you, Mr. Charles. Thank you, counsel.
Thank you, Your Honors.